Welcome, everyone. My name is Sarah Ray from the Bloomfield Public Library. Thank you for joining us today. We welcome back attorney Jeff Rivard, and today we're going to be talking about the probate process. I'm going to turn the mic over to you, Jeff.
Thank you, Sarah. Thank you, everybody, for coming. Hopefully, everybody's staying warm on this ridiculously cold day. Um, so when we talk about and as she said, I don't mind questions. Sometimes I get buried with questions. Sometimes I don't seem to get any questions. But I'll try to keep an eye on the questions, and to the extent I can sneak in some answers, that might be helpful. So hopefully everybody can see my screen. So when we say the probate process, one of the sort of initial points. Oh, sorry. So my name is Jeff Rivard. I'm one of the attorneys at Topeka, Daly, Pope and Perry. I mainly operate out of our Berlin office, but I'm in Simsbury sometimes. I'm in South Windsor sometimes, and sometimes I'm in our Farmington satellite office, which is my house. So I do a lot of probate. And when we say the probate process, I guess the first point I'd like to make is we could really look at that and say the probate processes plural. What I mean is if you have a loved one that passes away, the experience you go through might not at all be similar to the experience other people have gone through. I sort of use the model, you're out working on your lawn, you're talking to the neighbors, your mom has passed away recently, you're a little apprehensive, what's it going to look like? You talk to the neighbor on the left, he says, "Oh, my dad died last year. Wasn't too bad. I think I had to pay some tax or something and I filed some forms, not a big deal." Your other neighbor says, "What are you talking about? My mom passed away. What a nightmare that was. It was stressful. I'll probably never talk to my brother again. What a nightmare." Both of these models are sort of what could happen to you. And the nature of the beast is such that we have to go through a different process depending on a number of factors. And that's what I'd like you to walk away from today. We're not going to be able to tell you everything there is to know about probate at large, but I think we can give you a good sense of what these different paths look like. Because when somebody passes away in Connecticut, there's about 3 different routes we might have to drive down, so to speak. And this will be clear as we kind of go along. So what we should start off with is some basic definitions. Oh, people, we hear the word probate. We're not always clear what that word means. So I start off with a basic question: what is a probate asset? Well, I'll read this word for word from my slide. A probate asset is a solely owned asset that has no built-in mechanism for being transferred to a successor owner. Think of it as a two-part definition: one owner and no built-in way to automatically pass on to someone else. It's sort of like an orphaned asset. It's kind of stuck there until something happens with the probate court. And that's the second bullet point. You can also think of the word probating an asset. We need to go through a court process before somebody will have the right to collect or inherit on the back end of that. Now, that's kind of a little dry, and I think it might make a little more sense as we move to the next slide. If we have probate assets, well, we must then also have non-probate assets. Non-probate assets are things that we own in a way where we can avoid that formal court process, or technically speaking, our family avoids it because we won't be around anymore to deal with it if we were the original owner. So here's a few common examples of non-probate assets. We can own things jointly. A lot of married couples will own a joint bank account where they do their day-to-day bill paying. Most married couples, particularly first marriage, they're going to own their first home jointly. Why? They never even ask you. The real estate attorneys, they're just going to type up the deed that way, and that's perfectly fine. What that basically means is if we have A and B own something jointly, the full term is joint with rights of survivorship. If A were to pass away while B's alive, B by definition is now the owner. We don't need to sort of prove they own it. They own it because they have survived. I put in parentheses here something you can be aware of. There's another way, not quite as common, but there's another way multiple people can own something together, and that's called a tenant in common. What that means is basically, let's say my brother and I, we decided to buy some rental property together. We take title on the deed as tenants in common. What that means is we both own the property. We both have kind of the same rights, but we're considered legally different interests from each other. So if one day I pass away, he's still alive, nothing has happened to his interest. He's still sitting there. He still owns his 50%. My 50%, though, something has to happen. And we look at, how did I own my interest? Do I have a will? Maybe I had it in a trust, yada, yada, yada. But the point is, they are separate. And we get very different outcomes, whether some property is owned jointly versus tenant in common. Beneficiary designations, life insurance policies, retirement accounts, 401k, IRAs, annuities. These are various types of assets that are typically going to pass by beneficiary designation. And this speaks to my earlier slide when I said think of it as a two-part definition. I'm the only owner of this life insurance policy. I don't own it jointly with somebody. And yet it doesn't go through probate. Why? Because the policy says as long as I fill out the right paperwork, that insurance company is contractually obligated to send a check to the person I've designated. And we don't go through the court process to make that happen. Third and fourth bullet points are really variations of the second, but I put it on here because it's terminology you might come across. So what a payable on death is basically a mechanism where a bank will allow a account holder, a sole account holder, to attach one or more beneficiaries on an account. If that has been done, then that basically takes that account and sort of removes it from the pile of things that have to go through probate. Transfer on death, really the same thing, except for reasons that I'm not clear on. Investment companies like to use the term transfer on death, as opposed to banks that say payable on death. It's confusing. I apologize, but I don't make the rules. But really, these mean kind of the same things. And this last one, if something is owned as part of a trust agreement, this is another way we may satisfy that second part of the definition. Maybe I'm the only owner, but I've created this trust agreement, and now we have a built-in way of figuring out who's going to inherit this. Now, what's the answer of who's going to inherit it? I don't know. We got to read the trust agreement. The trust agreement is going to say, when I, Jeff, the grantor who created the trust, is passed, here's what I want to happen. I want the trustee to sell it, and it's going to go 1/6 to this person. And you've basically preset where that asset's going to go. Okay, so keep in mind this basic definition. We might have one or more probate assets. We might have one or more non-probate assets. And when I meet with a family, sometimes 100% is in one of those categories or the other. And we may often have a combination. And that's going to kind of govern which of these paths we have to go down. Now, this slide, this basic table in a nutshell, is giving you kind of the bare bones differences between the three most common processes that we might have to help a family deal with. All the way to the left, we have what we refer to as a full estate, full estate. This is the most formal process. It's the slowest process. There's sort of the most steps on that highway. Start to finish, we suggest as a rule of thumb, and the courts expect as a rule of thumb, it takes about a year on average. Sometimes shorter, sometimes longer, but the point is it doesn't happen overnight. It's a slower process. Now, when do we need a full estate? Well, first of all, we've identified, do we have probate assets or not? And that entails looking through deeds and bank account statements and correspondence from financial institutions to try to figure out whether we do or do not have probate assets. So let's say we have probate assets. Now we figure out the values. We figure out Kelley Blue Book value in the car. We grab a bank account statement. What was the bank balance on such and such a date when our person passed? They had 100 shares of IBM. What was the stock price of IBM on the day in question? Maybe we have artwork. Mom said that it was priceless. We might have to get an appraiser come in and say, unfortunately, this was a fake Monet worth 500 bucks, not 500,000. We do all that value, and then we ask, does it total more than 40,000? That's Connecticut's limit, 40,000. Not every state's the same, but Connecticut will say if you have more than $40,000 worth of probate assets, you got to go through the full process. 39,000, that's cutting it close, but technically we're not above the 40. And that's why if we're on the dividing line, valuation may be an important question. Now, the second prong here is regardless of the value, if we have any amount of solely owned real estate, no matter what the value is. Now, I say solely owned real estate. What does that mean? That means one person on the deed. However, if we have that tenant in common, my brother and I'm 50%, he's 50%, that's solely owned interest in real estate. And that would require this. I can think of a situation I had once where I met with a family and they brought it up almost humorously. We have no idea why mom bought that little piece of forest in Winstead. It's barely worth $2,000 as far as the town is concerned. Unfortunately, solely owned interest in real estate, and they had to go through the whole process. This third one, this is kind of a bit of a catch-all. And one thing you can appreciate is, for the most part, the pluses of avoiding the formal process and taking care of stuff informally. For the most part, the pluses outweigh the negatives, but there are a few negatives, a few drawbacks to avoiding the full process. And one of those speaks to this third bullet point on the left. Only in a full formal process do we actually have an official court-appointed fiduciary. We call that person the executor if our decedent had a will. If our decedent did not have a will, we might still need a court-appointed fiduciary. Then we use the term administrator. But suffice it to say, let's say the family is very aggrieved that mom passed. They believe that mom got inadequate, negligent medical care, and they want to see about possibly filing a personal injury wrongful death lawsuit. Well, if they go to that hospital and say, give us the copy of mom's medical records, the hospital's going to say, HIPAA, we can't give you any information, but they would be obligated to give information to a court-appointed fiduciary. So that's an example where we don't know for a fact whether we're really going to have a claim with value. It may be a nothing, but we may need somebody appointed fiduciary for purposes of getting that information. So let's shift now to this middle ground, small estate. What does that mean? Well, we've identified some probate assets, something more than zero, but we're not more than 40, and there's no amount of solely owned real estate, and we don't have the special circumstances. So here what can happen is somebody in the family would file an informal small estate affidavit. It's a way to sort of catch the leftovers. As I point out here, it's not super complicated, but it is something that has to happen unless they want to abandon that asset. If they say the only probate asset it looks like mom had was $100 savings account, they might say it's not worth bothering with. The most common asset that slips through the cracks, a vehicle. We don't think of vehicles as an asset. We think of it as entertainment, transportation. But if it's only one name on that title, even if it's only worth, say, $3,000, we need to deal with that. Okay. The one on the right, what says tax purposes only, this really only exists in Connecticut. Connecticut's the only state that operates this way. So Connecticut is one of about 10 or 11 states that has an estate tax return. The limits of what you're allowed to own in value, free and clear of the tax, is extremely high now. For last year's decedents, the first $13.6 million you own is free and clear of the estate tax. So we do occasionally run into families that are looking at an actual estate tax bill, but they're far rarer than they used to be. What's far more common is Connecticut is the only state that requires an estate tax return to be filed for everyone, whether you have a lot or whether you have a little. We'll come back to what that entails a little bit. But suffice it to say that when we meet with a family, that's kind of mission number one. We're trying to identify, do we need the full formal process? Do we only need the estate tax return? Or do we need this kind of middle ground? And by the way, the term small estate, don't mistake that to mean, oh, that's in only a scenario when the person didn't have a lot in assets. Perhaps I had $10 million worth of various investments, but they were all joint or they were in a trust. And it turns out the only thing that I owned in my sole name was that one $2,000 used car. Well, that's an example where I have a small estate, even though I have a lot of value of non-probate assets. Okay, hopefully that makes sense. Doesn't look like I have any questions so far, so I will keep on steaming here. So zeroing back in a little bit on that informal small estate process. So in order to collect that sort of modest amount of the kind of loose ends, we file what's called an affidavit in lieu of administration, which is awful clunky. So I typically just refer to that as the small estate affidavit. Now, this is a simple one-time ask. And on the document, we're kind of explaining why we're asking the court permission. Common scenario, husband passes away, wife says, I put the $10,000 funeral bill on my credit card, so I'm asking the court, the least you can do to help reimburse myself is I would like to take title to husband's modest value truck. That's what happens. Kind of nice and simple. If there's a will, we're still obligated to provide that to the court. That's part of state statute, but it's really symbolic. It's not really directly controlling anything the way it directly controls things in the formal process, but nonetheless, we have to do it. That's small estate. Now, zeroing in on this tax purposes only. So a few things. It's due within 6 months of the date the person passed. Here, we're referring to the fact that as of this year, it's now up to 13.99 million exemption. I'm sure everybody in this call is sweating that total based on our bank account balances. As we point out, I mean, a logical question is, okay, you say there's no estate tax, so why do they make you do it? Well, there's a very clear reason. This is a scheme that Connecticut has cooked up to fund our probate court system. In Connecticut, probate courts don't get direct state funding. The way they survive for the most part are by collecting fees. And the single biggest driver of fees are these non-taxable estate tax returns. So when this is filed, what gets filed if you're below the 13.99 million in this year is a 706 NT. NT stands for non-taxable. The larger ones, the full taxable estate tax returns, that goes directly to Department of Revenue Service. But all of these NTs, those get filed through the probate court. And that's a common point of confusion. I'll have a firm client will come back and say, oh, why did we do all this work? I thought we were avoiding probate. Well, the answer is yes, mom arranged her affairs to avoid that slow, frustrating year-long process. But in Connecticut, you can't really avoid this one-time obligation to file the estate tax return. That gets filed through the probate court, but it's not nearly as complicated. And one other thing that can make the family feel a little better is that's a confidential document. It's not part of the publicly available information that you do have in a full process, which is a big downside, particularly if it's one of those families where there's a lot of disharmony and the family says, well, what do you mean we got to put information that's publicly available? We don't want my estranged sister to see anything. So keep that in mind. I want to spend a minute talking about this as in red because this is very important. Connecticut is well aware that there are plenty of people that would prefer to not volunteer to pay this fee. And by the way, how much is the fee? The probate fee is about 0.4% ish. There's a table. It's almost like when you file your income taxes, a slightly different percentage applies, but you think of it as 0.4%. If I have a $20,000 estate, that's small. If I have a $10 million estate, that's pretty big. And actually, according to state statute, no matter how many billions you have, it's capped out at $40,000. They can never charge more than 40,000. There may be separately an actual estate tax, but the probate fee, $40,000. Now, if you have probate assets you don't want to abandon, well, now they got you because they're not going to allow anyone to inherit those probate assets unless they pay the probate fee. But let's take it one step further. State law says they want everybody to file these things, but perhaps there's no probate assets at all, nothing. There's really no incentive for the family to file and volunteer to pay this fee, and Connecticut knows that. So since I think it was 2005, they've built into the law that there's an automatic lien against all interest in real estate when somebody dies. Automatic, meaning nothing goes on the land records. It exists automatically. And as I've put in the red here, the way in which you get this lien released, the estate tax return is filed. All the assets are declared, including the particular parcel of real estate we're worried about. You pay that probate fee, which, by the way, probate courts operate very slowly, except when it comes to sending out those invoices. Those are lightning fast, next day. If we're waiting for other stuff from the court, sometimes it's weeks or months before they act, but that's neither here nor there. So the point is, the way the lien gets formally released is once you pay that probate fee, they send a hard copy certificate that we record on the land records. That's important. You might not notice the difference. Let's say you are the surviving spouse. Your husband died, you own jointly, and you've continued to live in the house for another 8 years, let's say. Well, as far as the town is concerned, nothing has happened. If you looked at the assessor's card, the property card, it's still going to say you and your late husband. They don't know any different. Where this really comes in to be problematic is you want to sell your home. You're tired of shoveling snow. You're tired of it being 0 degrees outside, and you're going to sell and move to Florida. And you're all set, ready to go. But then somewhere last minute, maybe the day before the closing, somebody looks at the title search and says, wait a minute. We have Mary. Where's George? Oh, George passed 8 years ago. We can't go through with this sale, or more to the point, the buyer is going to say, we can't go through with the purchase to get this lien cleared up. And this is something that a lot of people are not aware of. And this includes all sorts of interests. So it's not limited to solely owned. It includes jointly owned. It includes a variety of trust arrangements. So that's important. And that's why even if we don't have any probate assets, we need to deal with that estate tax return to get that lien released. Hope that makes sense. Now, let's spend a little bit of time talking about the full process since there's sort of the most to talk about there. So the first thing that happens is a petition is filed with the probate court. If there's a will, we have to give it to the court. That's part of the filing. And it has to be the original will. A lot of confusion out here. I'll meet with families and they'll say, well, I have a copy and my brother has a copy and then my cousin had a copy. There's only one original in the world. That's that wet ink original that our decedent signed way back when, that's what the court needs to see. And if it can't be located, it can be a big hassle because the court is kind of obligated to be skeptical. They're obligated to assume that if the family can't find the original, it's because the decedent got rid of it and revoked it. So you have kind of an uphill battle to prove your case if you're trying to get them to accept a photocopy. This second point, sometimes this is a non-issue, but sometimes this is a big stressful obligation. So a copy of the petition and the will, if we have one, has to get sent to any and all people who are named as beneficiaries in the will, plus the intestate heirs. What does that mean? You might have heard that term before, but if you're not clear on what that is, the laws of intestacy, pretty much every state that I'm aware of has a set of default rules that basically kick in to say if we don't have a will. The default rules are going to be based on the family tree. Is there a spouse or not? Are there children or not? If we don't have spouse or children, we then might say, are there parents? Are there siblings? Are the cousins? Are the second cousins? Somewhere down the line, we have people that might be kind of distant relatives, but somebody would inherit remaining probate assets by default. And one key point to understand here is the laws of intestacy don't care about your problems. They don't care if you approach the probate court and say, but Your Honor, don't you know that mom loved me and my brothers, but she couldn't stand our sister? Laws of intestacy don't care. Notice has to go to your sister, no matter how estranged she is from the family. She has a right to complain. She has a right to come in and say, I don't think that will was legitimate. I don't think mom was in a right state of mind when she signed it. I think my jerk brother Jeff forced mom to sign it. It wasn't really her doing. So the point is, family disharmony, this can be a very frustrating thing. Now, understand, once the will is admitted, those intestate heirs, their only bite at the apple is to fight kind of in the beginning of the game. If they don't fight or they come in and fight and they lose and the will's admitted, well, now they fall out of the equation. Now the will is the blueprint that governs what the executor does through the process and what they end up with. But I'm emphasizing this because it's important. If there's a lot of frustration with families if they understand this, which, by the way, thinking about estate planning for a moment, if you're in a family where there's a lot of disharmony, you might really, really want to double your efforts to avoid the need for this full process so that your family isn't in this dilemma. Last one, despite my emphasizing sort of dramatic disharmony, oftentimes we don't have disharmony. And in that situation, what can make the things go a little quicker with the probate court is if all of the beneficiaries sign a waiver form so that basically the court file, they can say nobody's complaining. Nobody's quibbling about that being mom's will. Nobody's complaining about the person she named being suitable for the task at hand. And there's really nothing they're ready to complain about. That makes the process go a little quicker. So, what are the things that our fiduciary needs to do? Again, an executor if they're named in the will. And if we don't have a will, we might still need a court-appointed fiduciary. We call this person the administrator. So what is the job description? Well, so first of all, the court is going to issue some hard copy probate certificates. Those have the fancy raised court seal, and that's what the fiduciary could take to the bank or maybe mail to an investment company and what have you. It's like your badge of authority. It's like you say, here's where the probate court named me fiduciary in such and such a date. It makes sense for the most part for the fiduciary to kind of gather all of the assets. And certainly if it's just basic bank accounts, if mom had 11 bank accounts at 3 different banks, it may be a hassle, but it makes sense to go close those accounts and get everything moved into one single estate account. And that account is when the fiduciary is kind of going to do all their business from there going forward. Do keep in mind when I use the word fiduciary, what that means is it's a legal position of trust. That person who asked to be named executor or administrator, part of that ask is the promise that you can be entrusted with going through this process. So you don't take the estate money and dump it in your own bank account and use it for your own personal needs. Think of it like you're running a business. You've got your estate account here and you got your personal accounts over here. And maybe along the way, you as executor can take some money to reimburse yourself for something, but you can't just put your hands in the cookie jar because you're short of cash and you want to pay a bill. The estate account is the estate account. Want to emphasize that. And this last one, they're quite literally going to want to safeguard the assets. That might mean mom lives in a rough neighborhood. She had a fairly expensive car in the driveway. You might want to make arrangements to have it garage somewhere safer, or you're changing the locks. Mom was ill. There was a bunch of home care health aides come in. We don't know who had keys, who didn't have keys. It makes sense to pay to change the locks. Maybe there's a painting in the living room. Mom always thought it was valuable. We don't know. Well, until we suss out the value, we might want to put it in a safer place. So when we have real estate is kind of treated a little more formally in the law. So one of the things that would happen is there's a notice that gets recorded on the land records for the town where the real estate is located. And that's basically so that in the short term, if somebody needs to know who's the legal owner of that property today, well, the answer is while the probate's going on, it's our fiduciary, it's our executor administrator. That's the point of doing that. And sometimes we have different towns involved. This second point, this is something to appreciate. If somebody passes away and they solely own real estate in another state, that can be a doubly frustrating scenario because your family might not only have to deal with formal probate here in Connecticut, they might have to deal with a whole secondary probate process. Maybe mom had a cottage on the Cape or a condo in Florida. So that's another sort of nod to estate planning. You really, really want to avoid that because that can get very frustrating. Somebody posed a question here. She asked, can the executor pay final expenses for the deceased bank account? Or must an estate bank account be created first and then used to pay final expenses? Well, here's the deal. Probate is a slow process. I always sort of say that probate courts operate at two speeds. They're slow and then they're slower. So even when the family's on the ball, we're on the ball, we get things prepared, we file it quickly, we don't get a fiduciary appointed overnight. There might be a month or more time lag no matter what we do. And there may be some things that have to get paid right away. So certainly if we consider the formal probate process, when we get to the end, I know I'm going slightly in reverse order. We get to the end, the executor files an accounting. And part of that accounting is the court wants to know, did anybody advance funds? Did anybody pay things out of pocket? So meaning son put the $10,000 funeral on his credit card a month before we had an executor who could access estate funds. Well, that goes in the accounting. Yes, son fronted the money for the funeral, and then executor, maybe it's the same person, maybe it's different, reimbursed him $10,000 from the estate account. So to go back to your point, the court is very receptive to making sure that the right people get reimbursed, but sometimes it's inevitable that there's things that we're going to get paid. Keeping the lights on, right? Maybe it's going to take a while and we don't want the pipes to freeze. So we're going to keep paying the electricity bill, even if we don't have access to estate funds yet. And that's why sometimes what people will do when they think about estate planning is knowing that we might have kind of a liquidity problem for a period of time. Well, they might decide, I'm going to deliberately put $5,000 in this specific joint account with my daughter, knowing that I can trust her to use that money to pay the short-term needs. You can do the same thing with a life insurance policy. Sometimes people do that to kind of bridge the gap between the two. Hopefully that helps answer the question. Okay, so within 2 months of the date the person is appointed as fiduciary, they file what's called the inventory. The inventory is the list of solely owned assets and values. Again, this is probate assets only. Non-probate assets, those show up on the estate tax return, not here. Valuation is funny. A lot of things we value are nice and simple. I alluded to the idea that we can, if it's a publicly traded stock, it's easy to figure out the value. We can do Kelly Blue Book value. Bank accounts, nice and simple. Sometimes it's hard. How do we know what that painting is really worth? We might need to get a qualified appraisal, somebody who's in the business of valuing art, to tell us what was this value. Or maybe dad was one of 8 partners in a business where he owned 11% and there was a complicated buy-sell agreement. That's a doozy to try to figure out the valuation. So sometimes this is a difficult process. We can amend the inventory as time goes on if we find more assets, but that's something that gets filed. Okay. And by the way, I said something. Let's come back to one of the reasons why a lot of people hope to avoid probate is that is public information. I have a copy somewhere in my office. It was a sheet from the New Britain Herald in 2011. The sheet was names and values. And what that was everybody in town that had died the year before and what was the value of their probate estate. So I always ask people, hey, who here wants your neighbors right now to know what's in your account? Everybody shakes their head and laughs and says no. If it's on a probate inventory filed by the executor, nosy neighbors could figure it out. So keep that in mind. What's next? Well, this is a big part of the executor's responsibility. There are claims. Now, understand a claim is not the same thing as an expense. A claim, think of it as either something our decedent owed when they passed, like a credit card with a balance, or maybe goods or services were provided to this person but billed after the fact. Uh, Dad was suffering from cancer. They ran some tests. After he died, Medicare took a while running their billing. And finally, 3 months later, they say somebody owes us a $200 copay. That's a claim. Technically, part of what the fiduciary is doing is evaluating whether they think all the claims are legitimate. There's a lot of identity fraud out there. There's confusion. Maybe you get a letter from a bank that claims mom owes money, but you say, when I was going through her paperwork, here's a letter from the same bank last year that said the loan was paid off. So if I'm the fiduciary, I could say to that creditor, you haven't made your case. Or, dad was ill. There's no way he opened up a new account at this bank in New Haven. I think this is identity fraud. And you could disallow a claim. And eventually, there's a list of these claims get presented to the court. And by the way, how do creditors know? Well, one of the things that the court is going to do is they're going to arrange to run a newspaper notice once. Courts around here are typically the Hartford Courant, but it doesn't matter. Each court has their favorite go-to publication, and they only have to run it once. And basically, any creditor in the world is supposed to be paying attention and seeing that. And they need to present it within a 5-month window. That 5-month time period starts the date the judge signs the decree saying somebody's executor. So that's an important part of the process. The estate tax return, we did already talk about this before. This is filed kind of midstream. So it's due within 6 months. We can always get a filing extension if we need it. We can always get a 6-month extension. Sometimes we need it, sometimes we don't. If we don't get the extension request in time, it's not the end of the world, except now the probate court adds interest onto the probate fee. So people are even happier when they see interest is accruing. So that's the estate tax return. And to make clear what I said, the estate tax return is the whole universe of assets. It includes both probate and non-probate. Interestingly, Connecticut wants every estate tax return to report any assets located anywhere in the world. So mom owned a home in Connecticut. She also owned a home in France. They want to know about the home in France, and we got to put it on there. We got to come up with a value. However, Connecticut is obligated to reduce fees and taxes by non-Connecticut value. So it's a little bit smoke and mirrors, but Connecticut has an incentive, if they can, to try to argue that somebody was really still a Connecticut resident. If mom moved to Florida and you tell Connecticut she was really a Florida resident, Connecticut's a much bigger probate fee if they can manage to say, well, she never stopped being Connecticut resident. So that's part of the reason why they want to know about all of those assets. The final accounting. So this is probably the most labor intensive part of the process. With a full estate like this, we get to the end and the executor is filing a full accounting. The starting point of the accounting is going to match the inventory. It's going to say basically, here's the value of what was in the estate when I started. Here's what's left now. And here's everything that happened in the interim. I paid some lawyers. I paid some accountants. I paid the funeral bill. I had to pay the people to help with the house clean out. I collected some dividends on the stocks. There's some interest in the bank accounts. I sold the house for a gain. I sold the other house for loss, yada, yada, yada. We may reach the end and we still own real estate, or maybe we've sold the real estate. So the accounting is going to include that. What was the real estate attorney's fees? What was paid to the realtors? Taxes, expenses, yada, yada. Claims. We have claims. I learned about 8 claims. I allowed 7 of them. The accounting is going to say, and I paid those 7. And then here's what's left. And with what's left, we have what we refer to as a proposed distribution. What is the fiduciary's game plan for distributing what's left? Well, if we have a will, that game plan should match what the will says. So if the will said, I want it to go 1/4 to this person, half to this person, and then 1/4 to my favorite charity, well, then that's where the game plan is going to ask the judge permission. There is a mechanism on occasion, if all the beneficiaries get together and they all agree to do something different, it's possible the judge would allow it, but it is discretionary. Why might we do that? Well, let's say I'm a dedicated but low-paid social worker, and my sister is an enormously expensive hedge fund manager. She has millions. I have hardly anything. She says, look, I don't need a penny out of Jeff's estate. I'm okay if brother Jeff inherits. They could sign a mutual agreement and ask to do something different, but that's kind of a rarity. The court's going to expect that the will's going to get followed. Conversely, if we have an intestate estate, we don't have a will. Now we follow those laws of intestacy, and there's really no room for ambiguity there. It's all based on the family tree. So that's what they're going to be. Now, I want to oh, and as I point out here, the court may or may not need a hearing. Just like the beginning of the process, the beneficiaries, we give them a copy. They have a right to either complain or not complain. And if they're not going to complain, it would be great if they sign a waiver so that the judge can see all the beneficiaries are happy with the accounting. Now, just because the accounting is filed and all the beneficiaries have signed a waiver, That does not mean a judge can't take it on themselves to decide something's not right here. So what's an example of that? Well, an executor or an administrator is essentially a service provider. And as a service provider, the law allows them to collect a fee, but that fee has to be reasonable. And literally, that's Connecticut standard. It needs to be reasonable. And I always like to think that when we have the word reasonable in the law, it means nobody knows what it means and people can fight over it. So what I think's reasonable and what you think's reasonable and what your resentful sibling thinks is reasonable or the judge may be four different things. So that's an example where maybe the beneficiaries have all signed a waiver. They're fine with their sister collecting a $50,000 fee, but the judge should come in and say, no dice, that's excessively large. So that's kind of the final account. I got a couple of questions here. Somebody says, do you have to include assets owned by the trust at any time during the probate process, or do you have to advise the court that a trust exists? We tell the court that a revocable trust exists as part of the petition, but technically speaking, the trust itself is not under court jurisdiction. The judge does not have direct say over what the trustee is doing. Trust assets, with rare exceptions, are going to show up on the estate tax return, but they're not part of probate. Now, that doesn't mean a court never intervenes in trust administration. They can be asked to intervene. State statutes allow the judge to have discretion. If somebody comes in and says, I'm the beneficiary of a trust and my uncle's the trustee and he hasn't given me a penny for 5 years, it's possible the judge could then say, we're going to exercise jurisdiction. We're going to haul the uncle in here. We're going to say, you give us an accounting and we want to see the trust and we're going to sort out whether this beneficiary really has a grievance. But when that's done, the court fades away. They're not permanently involved in the process. They are involved in the probate process throughout. So hopefully that kind of makes sense. Somebody says, how long does it take to get insurance money by the beneficiaries? That varies company to company. I think in general, I like to say insurance policies are fairly quick, but I really can't quantify that. So, maybe a couple weeks. I'm sure it varies from company to company, but for the most part, or put it this way, insurance is faster than probate. But if you have an account owned jointly with somebody, kind of for strategic, that's even quicker because that person can walk in the very same day somebody's passed and sort of has never lost the rights to the money. Hopefully that makes sense. Somebody said, if somebody's on Medicaid and they're in a nursing home, what happens to the small bank account they opened years ago and later added an adult child as a signer? Ooh, interesting. You went two ways there. If somebody's on Medicaid and they're the only owner of one small bank account, the state of Connecticut ends up taking that. It may take them a while to get around to approaching the bank, but they collect it directly. But interestingly, if that account is owned jointly with somebody else, the state does not have a right to collect it. The other person has a right to collect it. Typically, we're not talking about a large dollar value, but that is something worthwhile. We have one more here. We have a property that owes several years of taxes and family members haven't gone through probate. Can the town open a petition? That's an interesting question. I don't think they would. I think if I was the town tax department, instead what I would do is I'd probably go to Superior Court and I'd go through the foreclosure process. But it is an interesting question. If all the logical people don't seem to be acting, can another third party act like a creditor? In theory, I mean, it's rare, but the statute may give the right of first refusal to people that are named. But if nobody acts, the courts would probably get receptive to somebody else because the courts understand certain things have to happen. Last question. Somebody said the trust assets show up on the estate tax return. Is the estate tax return filed through revenue service or probate? Well, that's that 13.99 million dividing line. It doesn't matter that there's a trust. If we have $15 million owned by a 2025 decedent, that's DRS and that's a taxable estate tax return. 13 million below 13.99, that's probate court. And by the way, with a jointly owned asset, if it's owned husband and wife, a married couple, it's deemed half and half. So that $2 million real estate is only considered 1 million as our deceit. So only half the total goes up to that. Okay, coming back here, talked about the accounting. So what are some possible roadblocks we might run into? Well, as I alluded to, it is possible that beneficiaries or heirs, intestate heirs, could contest the will. That's something that sometimes we can predict based on what we know about the family. Sometimes we can't predict it, but it's something our firm deals with sometimes. Specifically, typically our litigation department gets involved in those kind of things. This second one, remember I stressed that a fiduciary by definition has agreed to be entrusted. Well, sometimes there's a breach of that trust. The executor has commingled their assets and estate assets. Or maybe the executor does something shifty. So let's say the executor happens to run a lawn care company. And as executor, they decide to hire themselves for egregiously expensive costs, way above the other guys in town that do lawn care. Well, that's a duty of loyalty, and it's almost like you're stealing money from the estate. So they need to be very careful to exercise reasonable diligence and discretion throughout this process, and understand that when they're doing this, agreeing to be fiduciary, there's really kind of two audiences, if you will. There's the other beneficiaries, and then there's the judge. And maybe the judge thinks things went fine, but the beneficiaries complain. Or maybe the beneficiaries don't complain, but the judge is going to complain. So you need to be mindful. And your roadmap is that will. The will is going to kind of have obligations in it, and that should be a good way to start by trying to figure out what the executor is supposed to be doing. This last one, this is really more a comment on estate planning, because by the time we get there, we can't change a will that's messed up. But sometimes the will itself is messed up. Sometimes there's problems. It was poorly drafted. Don't ever do this, but if you want to make a change to a will, your own will, don't ever mark it up yourself. Don't cross out the 10 and write 5, because when you do that, the court has no idea what that means. And a very conservative judge might look at that will and say, well, obviously he is wanting to make a change, which means we're going to treat the whole thing as revoked. So that's a kind of an odd example where it's really worthwhile actually seeing the lawyer and paying to make some changes. Don't try to futz with it yourself. Let's see. Was that my last? Okay. This is kind of just a quick reference, and I know I have a couple more questions that I think I'll get to, but today's topic is not about trust per se, but a revocable living trust specifically can be a very good tool for probate avoidance. It's almost the flip side where I was stressing, if you want to keep nosy neighbors or estranged family members away from the public record, what's in a trust or what the trust agreement says is not public information. And certainly as a single individual, for example, a widow or widower, a trust may be a very good way to avoid probate, but not running the risk of, say, adding somebody else on your deed jointly in case they run into problems. Let me take a look here. Somebody says, if a person places property in a trust, how is Medicaid affected? Well, that's a kind of a much broader consideration. If it's a revocable living trust, then by definition, while you're alive, it's still your asset. You control it. So that Medicaid looks at that just as if it's money in your own personal savings account. In contrast, if it's the type of trust we help clients try to protect assets and irrevocable asset protection trust, that's a different story. It's not your asset anymore from day one. You've gifted it away just as if you handed money to your kids. The flip side, though, is they're going to whack you with a penalty because of the 5-year look back period. If you want to know more about that, watch the schedule when we talk about long-term care and Medicaid. Somebody here says, who are the intestate heirs that could contest the will if there's no living parents, children, or siblings? Well, the short answer is it is harder to tell. I mean, I think of it this way. If we don't have spouse and we don't have children, then we look to parents. After parents, we look to siblings. If we don't have siblings, we probably look to first cousins. If we don't have first cousin, we look to second cousin. They're going to find someone. And depending on the situation, sometimes intestacy gives us exactly the results we would have expected, but sometimes we very much do not. I had a situation once where a fella had 2 elderly aunts that were very ornery, refused to do anything. He arranged for me to go to the nursing home, and this little old lady, if she could get out of the wheelchair, she would have decked me. She said, "You get your bleeping papers out of here. I don't want any of it." Surprise, surprise, it was a mess. And what did we need to do? We needed to try to track down some distant cousin in the Midwest because that's what the intestate heir was, even though it made no sense to the nephew who had tried to deal with this. So anyway, that's kind of long-winded, but you never want to rely on the laws of intestacy because we might get bad results. I don't know. I think, did I get all of our questions? I think I may have. And that's 2 minutes to spare. How about that? That never happens. Um, Thank you for listening. If anybody ever wants to, come meet with us about your individual issues, you know where to find us. I'm hoping you learned something from today. And you've been a great audience.
Thank you, Attorney Rivard. We'll see you soon, and I'll send everybody a copy of the recording and all of our other programs that we've done. Take care, everyone.